Hey everybody, so for the first Profile of Justice project I decided to do some research on Justice Stephen Breyer. So a little bit about Mr. Breyer. He was born August 15th, 1938 in San Francisco, California. His father, Irving Breyer, worked as a legal counsel for the San Francisco Board of Education. His mother, Ann Breyer, worked in public service. He married Joan Hare on September 4th, 1967, and they have three children, Chloe Breyer, Neil Breyer, and Michael Breyer. I found out that he is of the Jewish religion. He can speak French fluently, and he is an active Eagle Scout. And this right here is a quote that he said when independence means you decide according to the law and the facts. Some of his education: he got an AB from Stanford University, majoring in philosophy in 1959, a BA from the Magdalen College in Oxford, and a Bachelor of Laws from Harvard School of Law in 1964. I have a picture up here on the top right of Stanford University. In the middle, it's a picture of Magdalen College, and at the bottom, it's kind of unclear, but it is a picture of Harvard School of Law. His prior professions: he has quite a few prior occupations. He served as law clerk to Justice Arthur Goldberg during his 1964 term. He was the special assistant to the Assistant U.S. Attorney General for Antitrust from 1965 to 1967. He was Assistant Special Prosecutor of the Watergate Special Prosecution Force in 1973. This was originally the reason why I wanted to start researching Mr. Breyer. I was hoping I could dig in a little bit into what all went on during the year that he served as the Special Prosecution Force, but I was unable to find anything regarding the details of that other than that he was serving as the Assistant Special Prosecutor. He was also Special Counsel for the U.S. Judiciary Committee from 1974 to 1975. Chief Counsel of the U.S. Judiciary Committee from 1979 to 1980, Assistant Professor of Law and Lecturer at the Harvard University from 1967 to 1994, Professor of Harvard University Kennedy School of Government in 1977 to 1980. He was a visiting professor at the College of Law in Sydney, Australia, and University of Rome. I was unable to get the exact dates of that. He served as a judge and chief judge of the United States Court of Appeals for the First Circuit from 1990 to 1994. Served as a member of Judicial Conference of the United States from 1990 to 1994, and then served as a member of the United States Sentencing Commission from 1990 to 1994 as well. He was nominated for the position of Supreme Court Justice on May 17, 1994 by President Bill Clinton. As you can see to the right, this is where he is being nominated. He was confirmed on July 29, 1994 after Senate hearings brought an 87 to 9 vote confirming his placement. He was sworn as the 108th Supreme Court Justice on August 3, 1994 at 55 years old. As of the date of this PowerPoint, he is actively 81 years old. So a little bit about his judicial philosophy. I have a video link right below the picture. This picture was taken from the video itself. In the video, Breyer is having a discussion with Justice Scalia with a group of class students. And in the video, he made it very clear that his philosophy reflects more of the living Constitution philosophy than it does the originalism. In the video, Breyer is discussing the different views of controversial topics with Scalia. He does state in the video that the Constitution is an evolutionary document, which is very, very strongly supportive of the living Constitution philosophy. To support his perspective, he does refer to when the Bill of Rights was ratified, social media and the internet were non-existent. However, the right to free speech evolved to umbrella both of those in today's world. He has the belief that the Constitution must evolve to parallel the modern and ever-changing world. He doesn't believe that we need to take the words in the Constitution and give them the value that they had back when they were ratified. He also quoted that, "I believe that what I'm doing is taking the unchanging value of the words in the Constitution and applying it to the circumstances of today." So with that, he is speaking directly about his views. He doesn't believe he is changing the Constitution. He just believes he is applying what the Constitution says to the environment today. Justice Breyer has written quite a few books. To the right here, I've got 4 pictures. One of them is against the death penalty, so Breyer obviously, as the book title suggests, he is not for the death penalty, and we will, that's kind of foreshadowing to a case that I'm going to review in a minute. Breaking the vicious circle toward effective risk regulations. Let's see, Breyer's book, The Court and the World, and Making Our Democracy Work. Those are 4 books that I was able to find good pictures of. A few others that he's written is the Federal Power Commission and the Regulation of Energy in 1974. He wrote that with Paul McAvoy. Regulation and its Reform, he wrote that in 1982, or published that in 1982. Administrative Law and Regulatory Policy in 1992, he wrote that with Richard Stewart. Act of Liberty and Interpreting Our Democratic Constitution in 2007. Again, The Court and the World, American Law and the New Global Realities in 2016. And Against Segregation in American Schools in 2020. That is his most recent book. It was published in January. So he's very active in writing as well with his current occupation of being a Supreme Court Justice. One landmark case that I thought was very interesting was that of Lawrence v. Texas in 2003. In this case, both Tyron Garner and John Lawrence, who are both pictured to the right, were both arrested and convicted of deviant sexual intercourse after a Houston police officer entered their apartment while they were engaging in intercourse. So during this investigation, Texas had a law called the Homosexual Conduct Law, which criminalized sexual intimacy between same-sex couples, but not heterosexual couples. And so in this case, the court made the decision that statute that made it a crime for 2 same-sex couples to engage in sexual conduct was a violation of the Due Process Clause. They do have a right to liberty under the Due Process Clause to engage in sexual intercourse, though that they are homosexual. In this current case, Stephen Breyer joined the majority decision, which was a 6-3 decision. The case did overrule Bowers v. Hardwick of 1986, which brought a 5-4 decision that states could outlaw practices of sodomy. The next landmark case I have that I thought was very interesting was Steinberg v. Carhart, 2008. So Leroy Carhart was a physician who performed abortions in Nebraska. He pursued a suit questioning the constitutionality of the statute with the claim that it was unconstitutionally vague and placed an undue burden on himself and female patients seeking abortion. So the statute that he was questioning was one that people could not have a partial abortion unless there were serious circumstances as far as the mother possibly dying if the child was had. So that was what was discussed, and that's what was a question. And so, like I said, the case explored the question of, does the constitutionality of a Nebraska statute making the performance of a partial birth abortion a felony crime violate the liberty protected by due process in the 14th Amendment? To the right, I do have a picture. This was actually a protest that was had right outside the Supreme Court building during the decision, or right after the decision. So the court majority decision was actually delivered by Justice Breyer, that the Nebraska statute making it a crime to perform partial birth abortions did violate the Constitution, as previous precedents of Roe v. Wade, 1973, and Planned Parenthood versus Casey, 1992, were both interpreted and had the same viewpoint as well. Both precedents held that the decision to have an abortion was one that was protected under the Constitution. So the case did support that the females do have the right to decide if or not they want to have the abortion. This was a narrow majority of 5-4. I thought it was interesting. Justice Scalia delivered the dissent opinion, which summed up and paraphrased and stated that it is absurd to interpret the Constitution in such a way to believe it prohibits states from banning such an act of eliminating life. So Justice Scalia, obviously, he was not in agreement to this. He believes that basically the Constitution does not give people a right to basically terminate a life of another individual for no reason. The last case I have, and I think is the most interesting, is Glossop v. Gross in 2015. So this kind of has a long backstory. So Clayton Lockett was executed on April 29, 2014 in Oklahoma under their current protocol at the time of a 3-drug lethal injection method. However, the incident was far from ideal, as Lockett regained consciousness during the process and died approximately 40 minutes later after the first drug was injected. Oklahoma halted all future executions due to this until a new protocol was put in place. Eventually, it was put in place with establishing a 4-drug lethal injection method. With this new protocol, midazolam was used as the initial drug for the new method, just as the old method. Fast forward after a failed writ of certiorari, Richard Glossop and other death row inmates petitioned the court to hear the case, and it was granted. The case explored the question of does the use of the drug as the initial drug of lethal injection combination violate the 8th Amendment's afforded right against cruel and unusual punishment. The court decision said no. This is due to the petitioner failing to provide sufficient evidence that the drug is verified to induce severe pain and that another drug was less likely to cause as much pain. This was a 5-4 decision. Basically, the court said that there was not enough evidence to say that this drug is what caused Clayton Lockett to basically regain consciousness and possibly have an excruciating death since it was 40 minutes after that drug was initiated, and also the petitioner failed to provide an alternative drug that was verified to not cause as much pain and to basically be a better alternative than the current drug. I thought it was interesting as I was researching this that the 8th Amendment does not infer that a constitutionally sound method of execution be pain-free. It only infers that it is not cruel and unusual. Just because it can be painful does not automatically make it cruel and unusual. In this case, Justice Breyer actually wrote the dissent opinion arguing that the death penalty is unconstitutional because the constitutionality of a punishment must be based on currently prevailing social and legal standards. He further supported the dissent by noting exoneration rates being disproportionately high in capital crime cases. He continued by indicating the tremendous amount of time between sentencing to death and the actual execution is cruel and unreasonable, as it no longer supports the underlying purpose of the punishment, which is deterrence and retribution. As we all know, it can take up to 20 to 30 years from the time somebody is sentenced to death to the time that they are actually executed, and that is one reason that he says the death penalty is no longer constitutional sound, since it does take such a long amount of time. Other than that, these are just all the references that I had used for this project. I hope everybody enjoyed and got some information out of it, and I'm looking forward to seeing everybody else's.